Hello, everyone. Welcome to this month's webinar, 2026 Employment Law Updates, Key Changes Employees Should Know About. This free webinar is available for all WorkWise Compliance customers. My name is Rosie Donaldson. I'm the Key Account Executive for WorkWise Compliance, and I'm joined by my co-moderator, Dan Helfrich, who serves as our Senior Human Resource Manager.
Hello, everybody, and thank you so much for joining us today. The webinar is going to cover important new and updated federal, state, and local employment law developments that occurred in 2025 and are taking effect in 2026. After our discussion, you'll have the opportunity to consult with our guest attorney during a live Q&A session, where we'll address key questions submitted by attendees.
During today's session, we'll explore several significant employment law developments and how they may impact employer obligations this coming year. Our discussions will include general labor law developments and federal agency guidance, wage and hour updates, including major tax and reporting changes affecting employers, workplace safety developments and regulatory activities, and equal employment opportunities and benefit plan updates.
We'll also touch on other notable developments, including emerging state-level trends, and we'll conclude the informational portion of today's webinar with an overview of 2026 federal, state, and local minimum wage increases.
In the final moments of our webinar, our guest attorney will answer, for as long as time allows, live questions from our audience, providing you with the invaluable experience of engaging with a legal expert on critical issues. Our speaker will also offer key takeaways from today's session and will engage in the audience with poll questions throughout.
So today's webinar features returning guest attorney Jeff Fucci, who will help guide our discussion on recent employment law developments and their practical impact on employers forecasted for the year ahead. Jeff has joined us for several prior webinars, and we're pleased to welcome him back. Jeff Fucci is the founder and lead attorney of J. Fucci Law, LLC, a business-focused law firm where he serves as a trusted legal advisor and outside general counsel to hundreds of companies, from early-stage startups to established multi-state and international businesses. His practice regularly advises employers on employment law compliance, risk management, and workforce strategy. Prior to founding his firm, Jeff gained experience at large law firms in the New York City metro area, served as a judicial law clerk in New Jersey, and taught as an adjunct law professor at Seton Hall University. He earned his JD from Vermont Law School after completing his undergraduate and graduate studies at Seton Hall.
Thanks for having me, Dan and Rosie, and it's great to be back with you again. Many of my clients are entrepreneurs, business owners, and managers across a wide range of industries. I work closely with them on matters involving labor disputes, employment negotiations, workplace policies, contracts, and compliance with federal, state, and local regulations. Staying informed about changes in employment laws is extremely important for businesses of all sizes, and I'm looking forward to walking through some of the key developments in 2026 with you today.
Thanks, Jeff. Before we proceed, we want to make sure that everyone can see and hear Jeff clearly. If you're experiencing audio issues, please check the volume on your computer or mobile device, and some users may need to log back in to improve their connection. And if that doesn't solve the issue, please let us know in the chat and we'll do our best to help improve the audio.
All right, so at this time, I'd like to go ahead and ask our first poll question. Today's webinar session is heavily dependent on audience participation. So to ensure that we're prepared to fill today's hour with helpful content, we'd like to know, what are you most interested in hearing about today? General labor law topics, wage and hour rules, workplace safety obligations, harassment and discrimination updates, or benefit plan updates? Please select whichever apply. We'll give you a few more moments to answer. All right, and so it's looking like most people are interested in general labor law topics, so we'll try to spend a little extra time on that today. Thank you so much to everyone who participated.
As your Q&A session co-moderator, I'll direct any audience questions to our guest speaker. and these will include questions submitted during our live session and any questions submitted during the webinar registration process. Please keep in mind that your questions may be slightly modified before being presented to the subject matter expert. The purpose of this webinar is to provide accurate and authoritative information regarding the subject matter being discussed. However, this webinar does not constitute as legal advice. Depending on your state, type of business, and number of employees, the laws and topics discussed today might require you to take specific actions. We strongly recommend working directly with your legal counsel and human resource professionals on matters that pertain to your business. WorkWise Compliance, the webinar host, and our guest speaker are not liable for any errors, omissions, change to laws, regulations, or interpretations, or for any actions taken in reliance on the information presented during today's session.
So for attending this webinar session, WorkWise Compliance is giving you our 2026 New Year, New Laws e-guide. This resource includes more information about the topics we'll discuss today, including important links to agency news releases and full versions of regulatory text and guidance. This resource also includes a state-specific chart that lists new laws affecting specific states. A short description of each law is included, as well as links to the regulatory text. As an attendee, you'll also receive a 2026 minimum wage map, which includes minimum wage information for states with recent changes. Today's slide presentation, equipped for note-taking, is also being provided to attendees. All these resources are available in the Materials section of GoToWebinar. And at the end of the session, you'll receive a downloadable certificate via email as proof of your attendance today. Also, I want to invite everyone to submit any questions you may have during the presentation by using the Ask Question feature of GoToWebinar. Most questions will be saved for the end of today's session, but those relevant to the discussion may be posed where appropriate. So with that, let's go ahead and get started. Jeff, let's start with an overview of any important employment law developments that took place in 2025.
Absolutely, Dan. So over the past year, both federal and state labor and employment laws have continued to evolve, though not always in the ways that many employers expected at the beginning of 2025. Employers saw the longest government shutdown in history, as well as the impact of the new administration taking over in the first year during this new presidential term, including the passage and signing of a far-reaching legislative act known as the One Big Beautiful Bill, or OBBB for short. Overall, we've seen a combination of legislative activity, agency guidance, and court decision-making shaping the employment law landscape together. In some areas, federal agencies have focused more heavily on issuing guidance and clarifications rather than rolling out sweeping new rules. In other areas, proposed regulations and enforcement priorities have continued to develop and shift, and in some cases, they've faced legal or procedural limitations. During today's webinar, we'll walk through several of these developments, including changes affecting workplace contracts, wage and hour compliance, workplace safety, equal employment opportunity, and employee benefits. We'll also highlight areas where employers should pay close attention moving forward, and particularly those areas where guidance is still evolving.
That's a helpful overview, Jeff. With that broader context in mind, let's start by examining some general labor law developments, including recent guidance and actions by federal agencies that employees should be aware of.
Yeah, that's a great place to start, Rosie. So let's first dive into the current federal landscape. One of the most notable trends we've seen over the past year is a renewed focus by federal agencies on compliance assistance and clarification, rather than introducing broad sweeping mandates all at once. In several instances, agencies have rolled out programs and guidance intended to help employers identify and correct potential issues proactively before those issues rise to the level of formal investigations or litigation. Agencies have also resumed issuing opinion letters and interpretation letters, which we'll cover and explain in just a few minutes. In July, the U.S. Department of Labor, which we'll refer to in today's presentation as the DOL from time to time, they announced the expansion and relaunch of several self-audit programs designed to help employers, unions, and benefit plan administrators assess compliance with federal labor laws. One program many employers may recognize is the Payroll Audit Independence Termination Program, or the PAID program, which has been brought back by the department. This program primarily focuses on compliance with the Fair Labor Standards Act, or the FLSA, and the Family Medical the Family Medical Leave Act, or the FLMA, and allows employers to work towards early resolution of certain types of wage and hour disputes. In addition to the return of the paid program, several agencies within the Department of Labor now offer formal voluntary compliance and self-correction options. These include programs through the Wage and Hour Division, the Employee Benefits Security Administration, and the Occupational Safety and Health Administration, which we all know as OSHA. While these programs are designed to encourage good faith compliance and may in some circumstances reduce penalties or limit the scope of an investigation, they don't automatically provide blanket immunity from enforcement. Employers should view them as proactive compliance tools that they can take advantage of, and they should consult with their legal counsel before deciding whether participation is the best course.
So Jeff, along those same lines, the DOL also recently relaunched its opinion letters program. Can you explain what that means for employers?
Yes, Dan, that's very interesting in the world of law and hierarchy, because the way agencies issue opinions, they sort of have an interesting position in the legal hierarchy of documents. They're not quite the same as court opinions. They're not quite the same as legislative statutes. They're something else. So I'll explain a little bit about what they are and maybe give everybody an idea. At the functional level, companies are probably very used to reading them and trying to say, does the situation in this opinion match what's going on in my workplace, if they're tied into those different agencies and their opinions on their websites. So in June of last year, the DOL announced the return and the expansion of its opinion letters program, which provides official written interpretations explaining how federal labor laws apply to specific factual situations, so sort of like what-if scenarios. This program now spans 5 enforcement agencies within the department, including the Wage and Hour Division, OSHA, the Employee Benefits Security Administration, the Veterans Employment and Training Service, and the Mine Safety and Health Administration. Opinion letters can be very helpful because they address real-world workplace scenarios and promote consistency and transparency in different situations. However, employers should keep 2 important limitations in mind when trying to rely on opinion letters. The first of these limitations is that opinion letters are not binding on courts. So if the opinion letter gets challenged at the court, it could be overturned. Second, opinion letters reflect the agency's interpretation at a particular point in time, and they could change with future administrations. And in fact, they very much do change often between one political administration coming in and the next. And in the last history of several years, we've seen the party politic of Washington change from one party to the next almost every term. So these opinion letters are prone to changing with each administration, especially when each administration changes parties with each election. Excuse me. Just recovering from a small cold. As a result, opinion letters should be treated as guidance, not permanent guarantees from the government, and they should be reviewed by legal counsel familiar with the hierarchy of laws and aware of how state laws and judicial rulings can put limits on the scope of the guidance that's provided.
All right. Another topic that's generated a lot of attention over the past couple of years involves non-compete agreements. What's the latest on that?
Yeah, we spent a lot of time on this last year, Rosie. That's a great question. In September, the Federal Trade Commission, or FTC, formally moved to dismiss its ongoing court appeal of 2 major decisions that had blocked the agency's proposed nationwide ban on non-compete agreements. As a result, the FTC's prior attempt to implement a broad federal ban is no longer moving forward. It's important to understand what this does and does not mean at a practical level. The dismissal of these appeals does not amount to a judicial endorsement of non-compete agreements, and at the same time, it doesn't prevent future scrutiny of non-compete agreements. Instead, it reflects a procedural and administrative shift by the federal government, specifically the FTC, Federal Trade Commission, showing how the priorities of that agency have shifted, and they're not paying as much attention to the nuances of non-compete agreements anymore. So where does that leave us? For employers, this means that non-compete enforceability continues to be governed primarily by state law, by contract law, and not by federal law overriding it. While some states permit non-compete agreements under limited circumstances or with specific guardrails in place, like physical geography, industry, or time frame limits, other states restrict or prohibit non-compete agreements entirely. One of these states is California. It's almost impossible to get a non-compete through in the state of California. Additionally, FTC leadership has indicated that the agency may still pursue from time to time targeted enforcement actions or focused investigations where non-compete agreements are viewed as being abusive or dangerous to business competition, anti-competitive. Employers should continue to review any restrictive contracts that they have in their company operations and be careful to avoid assuming that federal attention on the issue has completely disappeared. Historically, the non-compete ban has been in a state of flux for years now. In my work, I draft, revise, and interpret many employment contracts, and I do this both employer side and employee side. My businesses and my people bring me contracts to look at all the time. And what I've been advising them to look at is that their focus on any kind of non-compete language has to be really twofold. You can really only have effectively, and as kind of a guaranteed something that's going to work, a restriction in use of confidential information that's strong, and a preservation of employer rights regarding creation and assignment of intellectual property that's also strong. You can't necessarily have a very strong non-compete anymore, but you can have strong confidentiality and intellectual property or IP sections that say you're not allowed, you, the employer, you're not allowed to use confidential information for the purpose of soliciting clients or soliciting work opportunities. For example, if an employee works in a company and makes contact through their work for the company with an opportunity, the vendor they make contact with could be considered confidential information, and they wouldn't be able to contact them for a certain period of time. That's how you enforce non-competition. Focusing on the confidentiality and IP sections like I'm talking about can thus have the same protective effect as a traditional non-compete used to, while sufficiently narrowing the scope of the language and converting restrictions into something that will hold up in the modern employment landscape.
Thanks for that information, Jeff. Let's move on to wage and hour developments, which continues to be an area of focus for employers across industries, particularly with several significant changes tied to the OBBB.
That's right, Dan. Wage and hour compliance remains one of the most common sources of employer risk. And over the past year, we've seen a mix of new tax-related rules, reporting guidance, and enforcement changes, all layered on top of long-standing FLSA requirements. It's important to keep in mind that while some of these changes are new, the underlying wage and hour framework hasn't really changed, and employers still need to ensure they're complying with core FLSA obligations.
One of the most talked about wage-related developments involves the no tax on tips provision. Can you walk us through what employees should know about?
Yes, this is a major development for businesses with tipped workers. Under the OBBB, certain employees and self-employed individuals may be eligible for an above-the-line tax deduction for qualified tips. To qualify, the tips must be received by individuals working in occupations that customarily and regularly receive tips on or before December 31st, 2024. The Treasury Department was directed to publish a final list of qualifying occupations, and that list has now been released. Employers should understand that eligibility is tied to both the occupation itself and whether or not the tips meet the definition of what are defined in the statutory framework as qualified tips. Just as importantly, this is a tax provision, not a wage and hour exemption. It does not change minimum wage, overtime, or tip credit rules under the FLSA. The Treasury Department also introduced a Treasury tipped occupation code system, grouping qualifying roles into several broad categories, such as food service, hospitality, personal services, and transportation, maybe the usual suspects when it comes to tips. Rather than walking through the entire list today, employers should review the Treasury's final occupation list carefully to determine whether specific roles they have in their jobs, in their workplaces, are covered. We will provide a link through WorkWise in the chat window for our audience watching today. The regulations also draw a clear distinction between qualified tips and service charges. For example, mandatory service charges such as an automatic gratuity added to a bill, like for a large party, are generally not considered qualified tips, even if those amounts are later distributed to employees. The distinction is especially important for restaurants and hospitality industry employers where they see that often.
So Jeff, we're also received a lot of questions from customers about how these changes affect Form W-2 reporting. Can you address that?
Yes, and this is where employers need to be especially careful and where our audience, I hope their ears will perk up a little bit because we're going to talk a little bit about a few examples of this today. This is the idea of prophylactic examples of guidance coming out from the government about what things are going to be like in the future and not necessarily what they are like now. So it's be prepared, like my old friend says in The Lion King, be prepared, but don't overdo it. Don't change things now for regulations that haven't taken effect yet. So we'll get into it. And just just think about it that way. It's good to be prepared, like Scar says, but you don't want to start changing things now because the laws haven't fully taken effect. So employers need to be careful. Although the OBB requires new information related to qualified tips and qualified overtime compensation, the IRS has made it clear that Form W-2 will not change for tax year 2025. Tax year 2025 is being treated as a transition year. The IRS has released a draft Form W-2 for 2026 that outlines how the information may eventually be reported in the future, including the use of new codes and new fields. That draft, though, is not final, and employers should not implement changes based solely on the draft when they're doing their taxes this year for last year. The takeaway here is that preparation, not premature action, is the way to go. Employers should begin evaluating their payroll systems and their internal processes and their data tracking capabilities, and they should be ready when the final guidance is issued, but they should not jump ahead and act as if the final guidance is already in place.
All right. Jeff, there was also a guidance issue late last year regarding penalty relief tied to tips and overtime reporting. Can you walk us through that?
Yes, Rosie. In November, the Department of Treasury and the IRS issued guidance providing limited penalty relief for certain tip and overtime information reporting requirements for tax year 2025 under that one big beautiful bill. Under this guidance, employers and other payers generally will not be penalized for specific reporting errors related to cash tips and qualified overtime compensation, provided that complete and accurate returns are otherwise filed. This relief was created in recognition of the fact that these requirements were enacted relatively late in 2025, kind of on the way out of the door from the last administration, and many employers didn't have the opportunity to catch up and capture all of the newly required information. However, the relief at this point is temporary and transitional. The agencies have made it clear that tax year 2026 should be treated differently than tax year 2025, and employers are expected to be fully compliant moving forward next year.
All right, great information, Jeff. I think it's a good time to stop and ask a quick poll question. Now that we've gone over some general labor law updates for 2026, we want to know which of the following you would like more information on, and this can be provided in an e-guide or a standalone webinar. Understanding the no tax on tips, no tax on overtime rules, preparing OSHA inspection and minimizing potential penalties, wage and hour audits and self-audit best practices, updating your policies and handbook with recent law revisions, or preventing and properly investigating harassment and discrimination claims. Please select a topic that interests you the most, and we'll give you a few moments to answer. All right, looks like the updating your policies and handbook with a recent law change is the most popular answer. So we really appreciate that. And thank you again to everyone who responded.
I had a feeling people really like our handbook webinars. That's a good one. So beyond tips and overtime, Jeff, the IRS has also released several FAQs tied to the OBBB. What should employers take away from that?
I like it too, Dan, because that's one of the top things I do in my work is change employment handbooks. So this is a good day all around.
Me too.
Yeah, so we're all doing good. We're all on the right line of work. Based on the question about the IRS, the key message we're taking here is that the OBB, the one big beautiful bill, is still being put into practice at the agency level, multiple agency level. The IRS and Treasury are issuing guidance incrementally to address specific issues, including reporting thresholds and transitional relief. Some of these updates, like changes to Form 1099-K, reporting thresholds, for example, may affect a broader group of employers, while others are more industry specific. Employers should not assume that every piece of guidance applies to them, but they should stay informed and evaluate relevance with their financial advisors and their legal counsel.
So switching gears slightly, the DOL also issued opinion letters related to overtime and other wage and hour topics. You want to talk a bit about that?
Sure. The opinion letters keep rolling out. The DOL released several opinion letters addressing overtime calculations, tip pooling, and joint employment. So joint employment might be when a person works for, I'll say it now so that when it comes up again, it doesn't seem like it's a strange concept. Sometimes you'll have situations where people work for multiple businesses owned by the same employer. This happens a lot in, I'm just thinking, you go to these small towns where you find out that like one outfit owns half the block, and half the block is a bunch of different things. One of them's a coffee shop, one of them's a bank, one of them's a tailor, but some large company in another state owns all those businesses. Well, maybe it's true that that person then has different people writing their checks for them, but they actually work for one employer. That's important under the joint employer rule and how that's figured out. So think about that when you work, perhaps when you get into especially maybe a small business and they have a lot of different relations and you're doing different tasks, getting checks from different places. giving checks to people under different business names. That's going to be something that they're looking at very closely now, and that's going to affect some of this tax rubric. So one important reminder from these letters that are coming out is that premium pay does not eliminate overtime obligations. In general, most forms of compensation, such as hazard pay or shift differentials, must be included when calculating the employee's regular rate for overtime purposes. The opinion letters also address the idea of tip pooling and reinforce that employees who customarily and regularly interact with customers may need to be included in a tip pool, even if their roles aren't traditionally considered tipped. This is some of the gray area before we talk about people like host people, people front of the house versus back of the house, and back of the house too. They don't always necessarily interact with customers in the kitchen, but certain kitchen staff are fitting into this qualification. Finally, the joint employment guidance clarifies that if two or more businesses are closely connected in how they operate or how they're owned, employees' hours worked at each may need to be added together, and both businesses could be held liable jointly for following labor laws jointly.
All right, thanks, Jeff. There was also a change in how the DOL approaches liquidated damages in certain investigations.
Yes, that's correct, Rosie. Let's get into that important enforcement change, which I think our audience will be happy about because it comes off a little bit like a break. So in mid-2025, the DOL's Wage and Hour Division issued guidance stating that it will no longer seek liquidated damages in supervised resolutions involving unpaid minimum wages or overtime. This does not, however, eliminate liquidated damages altogether. It applies only to specific circumstances and does not affect cases that make it to litigation. For employers, the takeaway is that early resolution can make a big difference if they can find a way to settle, but any investigation should still be handled carefully and under the guidance of legal counsel.
The last on our list of wage and hour updates, the DOL withdrew a proposed rule related to sub-minimum wages. Can you explain that development for our audience?
Yes, the DOL formally withdrew a proposed rule that would have phased out sub-minimum wages for certain workers with disabilities. This serves as another reminder that proposed rules do not always make it across the finish line to become laws, and employers should focus on complying with current requirements rather than reacting prematurely to proposed changes.
All right, let's shift gears now and talk about workplace safety. As always, Jeff will walk us through what is actually enforceable today, what has changed recently, and what remains under review. Jeff, let's start with OSHA enforcement.
This is an important update, particularly for small and mid-sized employers, because OSHA has revised its penalty and debt collection guidance in a way that's intended to reduce burdens while still emphasizing hazard correction. In July 2025, OSHA updated its Field Operations Manual, which is the internal playbook it uses when issuing citations and penalties. These changes took effect immediately. Under the updated guidance, OSHA expanded eligibility for penalty reductions based on employer size. Previously, employers with 10 or fewer employees could receive a penalty reduction of up to 70% if all hazards were corrected. So that was kind of like a break for the smaller businesses. That threshold has now been increased to include employers with as many as 25 employees. There's also a new 15% penalty reduction available for employers who take immediate steps to address or correct hazards once those hazards have been identified. In addition, OSHA expanded penalty reductions for employers who have no recent inspection history or who have been inspected in the last 5 years without any serious, willful, repeat, or failure to abate violations. Those employers may qualify for an additional 20% reduction. This is not OSHA going easy on employers. The reductions are conditional and they depend on good faith compliance and actual hazard correction. The general duty clause still applies. And the general duty clause, for those that aren't familiar with it, is a long-standing statutory framework where employers always have a standing requirement to provide a workplace free from recognized hazards that are likely to cause death or serious physical harm. Also, it's important to note that serious or repeat violators are not eligible for the new reduction.
So, Jeff, OSHA also issued guidance after the federal shutdown, clarifying citation timelines. What should employers understand there?
Yes. Well, in December 2025, OSHA confirmed that it had fully resumed normal enforcement operations following the federal government shutdown. Although OSHA continued to receive workplace safety complaints during the shutdown, some complaints weren't processed immediately because they didn't meet the criteria for what's called accepted activity. OSHA is now actively addressing its backlog and advises that employers should not resubmit old complaints. The agency also clarified that any extensions granted for challenging citations due to the shutdown have now expired, and employers once again have only 15 working days to contest a citation.
Thanks, Jeff, for reviewing that information with the audience. Before we move on to our next topic, I want to ask another poll question to gauge how long we should spend discussing it. We want to know, how often does your company conduct a self-inspection on workplace to identify safety hazards, whether that be annually, quarterly, monthly, weekly, or you're just not sure? Please select the most appropriate response for your business, and we'll give everyone a moment to answer. All right, looks like we're really close on a lot of answers, but not sure is the more popular one. So again, thank you everyone who submitted their answers.
All right, so Jeff, to wrap up this section on workplace safety, let's talk about heat stress, something we know a little bit about here in Florida. This has been a big topic, especially for employers whose workplaces include warehouses or outdoor settings.
It's gonna be tough, people, for Dan to wrap their head around this, because I guarantee that a large portion of our audience has been watching the news just for the weather the last couple of days. That's about 180 million people in America, which is half the country, prepare to be blanketed by snow. Let's try to think tropically and go to the heat rule for a moment, if we can. Try to imagine, there are still people working in very hot conditions, even during this time. It's been important, and then also snow doesn't mean that it's not going to be hot, in a couple months. It's been important to separate what's proposed from what's enforceable, and we talked about that before. OSHA recently announced that it received nearly 50,000 public comments on its proposed heat stress rule, which was initially developed during the prior administration. The proposal would apply to both indoor and outdoor workplaces and would trigger employer obligations based on heat index thresholds, so based on the temperature and the feeling of the temperature. As written, the proposal would require specific actions starting at a heat index of 80 degrees, with additional requirements kicking in at 90 degrees, including special access to water, rest breaks, monitoring, training, and written heat illness prevention plans being on the job site. That said, there is no final federal heat stress standard in effect at this time. Until a final rule is issued, if one is issued, OSHA continues to rely on the general duty clause to address heat-related hazards. This means that our employers are expected to recognize and address dangerous heat conditions that could hurt or kill their employees or visitors on site, but they are not required to implement the full framework outlined in the proposed rule at this time. OSHA is currently reviewing the comments it's received. The review could result in a revised rule, a final rule, or the proposal being withdrawn altogether, and that's very common for the rulemaking process for any agency. We just don't know the final outcome yet at this time. With this as the current state of affairs, employers should monitor developments, but they should not assume that the proposals reflect any compliance obligation that they have to follow at this time. Just follow the standard hazard duty rule.
So next, we're going to go ahead and turn to the Equal Employment Opportunity, where we've seen recent updates from both the Equal Employment Opportunity Commission, or the EEOC, and the Department of Homeland Security, DHS, that employers should be aware of heading into 2026. Jeff, let's start with the EEOC.
Thanks, Dan. In November 2025, the EEOC released updated educational materials focused on national origin discrimination. The updates included a new one-page technical assistance document titled Discrimination Against American Workers is Against the Law. The purpose of this document is to clarify that national origin discrimination is unlawful under Title VII of the Civil Rights Act of 1964, regardless of whether the affected individual is American or foreign-born. This guidance does not really change the law. Title VII has long prohibited discrimination based on national origin, along with race, color, religion, sex, gender, pregnancy, disability, age, and a group of other protected characteristics. What the EEOC is doing here is reinforcing that anti-American bias can also enter into the equation and can be unlawful, and that employers cannot justify discriminatory decisions based on business convenience, customer preference, or assumptions about immigration status.
Jeff, can you clarify how the EEOC defines national origin discrimination?
Yes, this is one of the least understood of the Title VII protected classes. I can try. According to the EEOC, national origin discrimination can include treating applicants or employees unfavorably or sometimes favorably because they are from a particular country or region, because of ethnicity or accent, or because they are perceived to be of a certain ethnic background, or a filial status. So sometimes when people are part of certain cultural supportive groups, or maybe they wear a flag that speaks to a certain controversy that's going on in the world or something, they may be associated also with national origin discrimination. It brings a little bit of that in as well. As it comes into application in the employment context, it can become present when there's a preference towards foreign workers or workers with certain visa statuses over U.S. workers, or importantly over each other, where discrimination is based on association, such as marriage to someone of a particular national origin, or close association with, or advocacy on behalf of individuals of a particular national origin. So we can think about a lot of the political situations we've had the last couple of years, and how people have sort of brought some of that to the workplace. And discrimination from both the alleged victim and the decision maker share the same national origin. The key point for employers is that bad intent on behalf of the employers is not always required to meet the threshold of enforceability from a governmental or legal perspective. Employment decisions based on assumptions, stereotypes, or common practices can also still result in liability. So even innocent mistakes can result in liability under Title VII.
And so what does that mean from an enforcement standpoint?
Yeah, from an enforcement perspective, the EEOC's national or origin discrimination guidance reinforces its expectation that employers will take reasonable steps to prevent and correct discrimination. Employees who believe they've been subjected to discrimination must first file a charge with the EEOC before they proceed to court. The EEOC has a process in place where they investigate the charge, and they may pursue litigation if they believe violations have occurred. Nearly 10% of cases that the EEOC gets every year involve national origin discrimination. That's a meaningful number, and employees should review hiring and employment practices to make sure they're staying on the right side of the national origin discrimination issue and all the Title VII protections. They should ensure managers understand what constitutes unlawful discrimination, and they should provide effective harassment and discrimination prevention training.
So before we move on, we want to hear from our audience on equal employment opportunity laws and regulations. We want to know which of the following you would like more information on, and this again can be provided whether in an e-guide or a standalone webinar. Whether it be preventing workplace discrimination complaints, best practices for I-9 and E-Verify, understanding protected classes, retaliation risk, state versus federal discrimination standards. Please select the topic you're most interested in, and again, we'll give everyone a moment to answer. Again, we're really close on a lot of these answers. Most popular being the best practices for I-9 and E-Verify. But yeah, really appreciate it, and thank you all for your responses.
So next on our agenda, we're going to talk about benefit plans. Jeff is going to walk us through what's changed, what's remained the same, and what employers should keep on their radar.
Thanks, Dan. I'll start with the updates that most employers will encounter first this year. Retirement contribution limits. For 2026, the IRS increased the 401k elective deferral limit to $24,500, with additional catch-up contributions available depending on the age and plan design. IRA contribution limits also increased to $7,500. Next, we talk about Secure 2.0 catch-up rules. The Treasury and the IRS finalized regulations clarifying how certain catch-up contributions must be handled. In particular, some higher income participants will be required to make catch-up contributions on a Roth after-tax basis. These rules generally apply to taxable years beginning after December 31st, 2026, and do not change fiduciary duties under the Employee Retirement Income Security Act of 1974, or the ERISA. The next thing we'll talk about is annual Form 5500 filings. The DOL, IRS, and the Pension Benefit Guaranty Corporation have released information together regarding copies of the 2025 Form 5500 series. While the updates are largely technical, employers must continue filing electronically through eFast2 using official forms. Informational copies cannot be used at this time for filing.
Thanks for walking us through the recent benefit plan changes, Jeff. Up to this point, we focused primarily on federal updates. However, we'd like to make sure that employers are aware that many states have also passed new or updated employment laws that are either already in effect or that will take effect soon.
Yeah, that's great, Dan. And states have a lot to say about employment law, and there's a lot of differences on a state-by-state basis. And we have really, 50 different small governments that exist that control that all under our one larger government. So we'll talk about it a little bit. We'll talk about California and New York because they're really, and people look these statistics up. I'm just going to kind of go off the cuff. I mean, they're really the largest population states and really the leading states when it comes to, legislation that's kind of new and cutting edge. That's just the way it goes. Those are the, everybody's proud of their state, and but those are the bigger two states and sometimes the two more fast-moving states when it comes to new laws. So these states frequently enact laws that other states follow up or use as models. California and New York often serve as testing grounds for new employment law concepts. And even if a law doesn't directly apply to an employer today at this time, requirements with their origins in California or New York may often appear in that state down the road when their legislature adopts it as a model. So we'll look first at California. California has several laws that took effect in 2026 that stand out because they focus less on wages and more on how employers structure employment relationships and communicate workplace rights. Here are some of the most notable new California laws. One significant change involves restrictions on so-called stay or pay arrangements, which became effective on January 1st, 2026. These laws limit agreements that require employees to repay training costs, onboarding expenses, or similar amounts if they leave employment early. California regulators view these types of arrangements as potentially restricting worker freedom and mobility, even when employers characterize them as reimbursements rather than penalties. California also expanded its employee notice requirements, including a new right to know notice obligation that will become effective February 1st, 2026. This requirement mandates clearer, standalone written disclosures informing employees of specific workplace rights. Importantly, penalties may apply for noncompliance, making this more than just a technical paperwork issue. Employers can no longer rely solely on handbooks or bundled acknowledgments to satisfy notice obligations. WorkWise will provide the link to the model notice to its customers, and as always, required annual notices that must be given to employees can be found on WorkWise's conditional notices page, with links on the posting instructions that come along with the posters that you have access to there. In addition, expanded personnel record definitions, effective January 1st, 2026, increase the types of documents employees may request access to and that employers must retain. These changes affect records related to performance, discipline, and employment decisions, and they shorten response timelines in certain situations. Taken together, these California laws reinforce the state's continued emphasis on transparency, documentation, and employee access to information, areas that employers outside of California should watch closely because similar requirements often appear in other states shortly thereafter.
You mentioned New York, and that's where a lot of my clients are, and that's where I am as well. Can you review those major laws that become effective in 2026?
Sure, Rosie, and that's where I am as well. So it'll be fun to talk local a little bit. New York also enacted several noteworthy employment laws that became effective throughout 2026, many of which build on the state's already robust compliance framework. Here are a few of the most notable new laws. First, the state of New York will join New York City and other states like California in restricting employers from requesting or using the consumer credit histories of applicants or employees for employment purposes. There are some narrow exceptions to this, but basically it means that employers are prohibited from using credit scores or credit reports to make employment decisions like hiring, firing, or promotion or demotion. Second, New York implemented workplace violence prevention requirements with core provisions effective January 1st, 2026. This is actually a very big one right now because for those of us from New York, the nurses are striking, and one of the reasons the nurses are striking is because they're saying the workplaces aren't safe and that there's violence in the hospitals. So there's been a mandate in New York City, there's been an effort in New York City to increase the workplace violence laws to protect among the industries, the nursing and hospital industry, which experienced a lot of chaos during COVID. So under this workplace violence prevention, there's a little local yokel stuff for our audience if you're in New York, but that was on the news just last night. So with core provisions taking effect January 1st, 2026, covered employers have to adopt workplace violence prevention policies, provide employee training, and in certain industries, implement physical safety measures like panic buttons. These requirements blend policy development, training, and operational compliance all together. In December 2025, New York enacted the Trapped at Work Act, which immediately prohibits employers from requiring employment promissory notes that force employees to repay training or other costs if they leave before a set period of time. That sounds a little like something we just talked about in California, right? While limited exceptions exist, the law reflects New York's broader effort to curb financial penalties tied to employee mobility. Employers who attempt to enforce prohibitive agreements may face civil penalties in New York of up to $5,000 per violation and exposure as well to attorney's fees. Overall, New York's 2026 laws reflect a broader trend towards hiring and employment agreements, mandatory training, and documented compliance efforts, which are themes that are becoming increasingly common nationwide.
Excellent overview, Jeff, on California and New York. Although we don't focus extensively on other state laws during this webinar, do you see any common trends emerging across other states throughout the country that it would be beneficial for our audience to hear about?
Yes, we can kind of in summary talk about a few themes that are showing up in multiple states. Workers' compensation updates have taken effect in states such as Delaware, Maine, New Hampshire, Oklahoma, Rhode Island, Vermont, and in Washington, D.C. Unemployment insurance changes are trending in states like Hawaii, Illinois, Iowa, Maine, Rhode Island, and Vermont. Paid family and medical leave expansions were enacted in states such as Delaware, Illinois, Maine, and Vermont. And these types of updates highlight how states continue to refine enforcement mechanisms and worker protections, even outside of the larger population states that I mentioned in the beginning. Many of these laws change in a way that results in revisions to mandatory workplace posters. I think it would be beneficial for our audience and for the WorkWise team to drop a link in the chat windows showing all of the recent posting revisions that have been released just recently. So if you're watching right now, the WorkWise team will drop that in, and you can take a quick look and see where some of those poster updates may have occurred. It may be time for new posters in your break room, hallway, or other public facing space.
Yes, great idea. That is something that I'm getting a lot of requests of right now. So that link is in the chat window now. And thank you for that look at the state laws taking effect across the country. I also wanted to remind the audience that a complete state-by-state list of new and updated employment laws is available in our 2026 New Year, New Laws e-guide, which can be downloaded in the material sections of the GoToWebinar. We'll also email a downloadable copy to all the webinar registrants for your convenience.
So as we close out the information portion of our webinar, we want to note that at the beginning of the new year, certain states, counties, and cities traditionally increase minimum wage rates for employees. In addition to the 2026 minimum wage map that we're providing, you can find a complete list of effective minimum wage changes within the 2026 New Year, New Laws e-guide mentioned earlier. Most states and municipalities require the posting or distribution of updated minimum wage posters. That doesn't include other municipal or conditional notices you might also be required to display. WorkWise Compliance is here to help you with poster compliance. Current subscribers can access all required posters and notices within our digital resource library, which I'll touch on later. If you have any questions about your subscription or becoming a subscriber, please contact a customer service specialist using the number in the chat window.
All right, thank you again. And I would like to thank you, Jeff, again, for all the great information that you've shared with us today. We're going to actually skip the last poll question that we have set up because we're running a little bit over and we really want to get to the Q&A session. So we're going to just skip over to that portion here.
All right, so today, to participate in today's Q&A session, I encourage everyone to submit questions through the questions feature in GoToWebinar. We'll do our best to get through audience questions raised by today's Q&A session, and all unanswered questions will be submitted to our guest speaker for responses and sent to you via email. Please note that after the Q&A portion, Jeff will provide his key takeaways for today's session. With that, let's look at our first question. So our first question is, what are the threshold numbers of employees for various compliance requirements, and how do those thresholds change employer obligations? It's a good question.
That is a good question. You know, we touched on it a little bit today in the presentation when we talked about the compliance with larger employers now being given a little bit of a break if they show OSHA compliance. We talked about that, you know, from 10 employees to 25 employees fitting under those And that's just really an example of how that works. So what you usually see is, as a general rule, a sliding scale of more regulations and more laws at the federal and state level applying to employers as they become larger. And that includes things like protective requirements. It includes things like employee rights. It includes things like labor law protections, obviously. And also it includes things like reporting. I'll give you some numbers just to think about because it is a great question. I'm going to give you some numbers that are the threshold numbers and what types of things you see when you reach those thresholds and cross them. So common threshold buckets and what changes are these. These are the points. If you have one or more employees, so really 1 to 5, that's where you deal with wage and hour compliance, discrimination harassment rules, final pay timing, I-9 verification, and workers' comp issues. And these vary state by state. If you have 5 to 15 employees, you'll be seeing additional protected classes come in and anti-discrimination coverage expanding. And that will significantly depend on the jurisdiction you're in. If you have 20 or more employees, certain federal benefits, rules, and continuation triggers will become relevant. If you have 50 or more employees, you take a major step up in your risk because federal leave concepts and employer-wide policies often need to graduate in sophistication to cover workplaces of that size. And finally, if you're at 100 or more employees, your reporting and your larger style compliance becomes even more common. And in a lot of states, there's a lot of requirements to document the pay structure with the state government as well. Best practice, HR should maintain an employee threshold tracker that uses both the concept of what the employees are on payroll and how many employees exist in each state. Because I know now with the remote workforce, I have a lot of companies that have employees in different places. It can be a question of how many employees are actually on the payroll. And then with certain types of laws, how many employees exist in each state at a certain given time. So those are the two categories they should organize that by as they track their workforce to see what their compliance obligations are.
Great answer. Let's see the next question. Hold on just a second here. All right, next question. What do employers need to know about new overtime earnings codes taking effect in 2026 under the OBBB?
Good question. I think the answer for that is kind of general, and we covered it a little bit. They need to know that it's time to track that, make a list of it, get the information on it, but don't be prepared to enter it into any filings that you're going to do until the next tax year coming up. So the one BBB's effect on the earnings codes changing doesn't take actual practical effect until tax year 2026. So if you're paying quarterly taxes, if you're that type of business, if you're structured that way, or you're paying taxes in some other kind of increment, it's important to know when those codes take effect. If you're going to pay your taxes at the end of the year, which is probably most businesses, or if your fiscal year is structured a little differently, however it's structured, just remember that 2026 beginning in January is when the codes become effective, and not now while you're hopefully not rushing, but whatever you're doing to get your 2025 taxes together. Don't misapply the new codes to the last year's tax filing. So just keep that information. Got to keep them separated, and then you can deal with that next year with 2026. So be aware, but don't jump the gun yet.
All right, we got time for one, maybe two more questions here.
Get them in. I love questions.
Are there any changes to how a work week is defined for overtime purposes?
Oh, that is a good question that I might not regularly have the answer to offhand. A work week, I don't think there's been any changes to it, but I think I want to hold on to that question and get back to that with the written guidance we'll provide, because I want to check and make sure that we have the right answer to it. So I'm going to put a pin in that if it's okay, and we'll give everybody back, like we always do with these WorkWise seminars, we'll give everybody back written guidance to the bulk of the questions we have. And that's kind of like an added bonus for our listeners. So I'll answer that one more comprehensively in writing, because I don't want to make it up, and I'm not sure offhand.
All right, let's do one more question here. In the delivery business, if the employee's car's AC is not working, is this the employee's issue or the employer's issue?
That is a very specific, unique, and interesting question. In the delivery business industry, that would be, generally speaking, a contractual issue. So it's going to depend on what the arrangement is between the employer and the vehicle driver in terms of whose car it is. So let's think of two examples. I'll give you the pizza delivery boy or woman or girl, pizza delivery person, and I'll give you the Amazon person. The Amazon person could be, but is most likely, and if you live in an urban area, probably driving Amazon's vehicle, right? And they could be driving their own vehicle, but they're probably driving Amazon's vehicle. It's one of those electric looking, got the cute little circle eyes and the smile on the side of the van. They're probably driving one of those. Now that van belongs to Amazon. So I'm going to say that in that situation, if the car's AC isn't working, it's the employee's issue, probably in terms of internal policy to report that the AC isn't working, and then it's probably the employer's responsibility under OSHA type rules and under workplace safety type rules to fix the AC, because in many areas that could be a health and safety issue. Not even getting into the heat standard like we talked about, just basic health and safety issue. You probably can't have a non-working air conditioner in a vehicle in the summertime. So two sets of responsibilities come into play there. The employees to report based what's on probably an internal policy, and then the employers to fix based on what the hazard mitigation, OSHA rules are going to require. That's how that would go for the Amazon van. But then I know we got to wind it down. But for the pizza delivery person, boy or girl, however that goes, for the pizza delivery person, if they're driving their own car, it's probably going to be their own responsibility because they're probably an independent contractor and they probably bring their own tools to the trade. So in that situation, it's going to be their own responsibility, and whether or not they can get the employer to help them fix it is going to be a matter of basic contract principle. Hey, Papa Joe pizza guy, can you help me fix my air conditioner because I'm driving this car around all summer and I'm driving it for you? And maybe he says yes, or maybe he says no. But that's kind of what it comes down to. It's going to depend on the workplace situation, and a variety of obligations may ensue, all of them based upon principles of contract law, with a little bit of safety probably mixed in if you're dealing with a company-owned vehicle.
All right, we're going to try to squish in one more question here. We're going to make it super brief. Next question, please. Okay, there we go. Which 2026 changes pose hidden compliance risk for multi-state employers? And what system should HR adopt now to manage them?
I'm going to answer that question in the broadest way possible. Everything we're talking about for 2026 in terms of reporting is facing a very solidified new landscape of employees working all over the place. And companies now, the COVID situation where people worked remotely led to people working in different states. The current setup for companies in general has sort of solidified that, and now people work all over the place for companies that are centrally located somewhere else. Everything we've talked about today in terms of how you track your reporting, whether it's 2026 or last year's rules or the rules going forward, we can get more specific on this one and answer a little bit more detail in the writing. But the basic idea is you have to be able to track your workforce, and you have to understand the laws at the federal and state level that apply to the workers. And then you have to track the workforce and base a lot of it on where the workers actually physically are when they're doing the work. A lot of employers get this wrong. They don't mean to. They don't have bad intentions, but they forget sometimes that the laws that apply to their workers are the laws that are in the state where the employee is performing the work. So for the people that are all over the place, working for companies remotely, if they're employees, they have the protections of those states where they're situated. Not necessarily the rules of the state where the company is based. So as companies, I see this a lot with my startups, as companies have lean staffs that are spread throughout the country, they have to be aware of the laws in each of those states. And that's the biggest compliance risk for the multi-state employers universally, 2026, 2027, 2025, any year. As we continue to move technologically forward, that's the issue. You have to know the laws of the state. So get those posters for those out-of-state people. And I know we've talked about this before, WorkWise, get those posters for your one out-of-state employee up in Alaska there, and send the compliance posters to them in an email so that they're aware of them, up there in their hut, wherever they're living in Alaska, wherever their cabin, so that they know what they're supposed to be following, because that's important, because that's where they are.
All right. Thank you, Jeff, again for answering the questions. And unfortunately, we've run out of time. All unanswered questions I've just mentioned will be forwarded to Jeff's email, and then his responses will be sent to all of the attendees in the next couple of days. And thank you to everyone who submitted questions for today's sessions, and for Jeff for taking time to answer them. I would like to remind all attendees that you can access again the 2026 New Year New Laws e-guide along with today's slide presentation and the 2026 minimum wage map attached with handouts to the GoToWebinar. Jeff, can you leave us with some key takeaways on the labor and employment laws that we discussed today?
Yes, I'll try to go through them super fast because I know that we're winding down towards the end. And I'll throw a quick just 1, 2, 3, 4, 5 so everybody knows. Number one, stay aware of federal, state, and local employment changes. We just talked about that. Employers should regularly monitor not only federal developments, but also state, county, and local requirements that may affect their workforces. With all of the new 2026 minimum wage rates now effective throughout the United States, employers must make sure that they are applying the correct rate and displaying the required notices for all applicable jurisdictions and all required locations in their workplaces. Number two, pay close attention to wage and hour compliance. Changes related to tips, overtime, reporting requirements, and enforcement priorities make this an area of increased risk at all times. Employers should review classification decisions, payroll practices, and record-keeping procedures to ensure they align with current guidance. Number three, use available compliance tools proactively. Federal agencies are increasingly offering self-audit programs, opinion letters, and penalty relief initiatives. When used appropriately and in consultation with legal counsel, these tools can help identify and resolve issues before they escalate. Number four, understand that employment agreements and documentation are under great scrutiny these days. States are placing more emphasis than ever on written notices, personnel records, training requirements, and the structure of employment-related agreements. Clear, transparent documentation is becoming just as important as what we've always known as important, pay compliance. And finally, benefit plan changes require coordination, but they don't require panic. Annual contribution limit increases, future effective Secure 2.0 rules, Form 5500 filing requirements, and new optional benefit programs all require awareness and planning, but they don't require an immediate jump the gun redesign. As always, consult with a legal professional before making any significant changes to your policies or employment practices. Whether adjusting pay, revising policies, implementing new benefits, or responding to agency guidance, proactive legal review can help employers avoid unintended compliance issues as they arise.
Thanks, Jeff. I'd also like all attendees to know that they'll receive a follow-up email with a certificate as proof of attendance, along with a recording of today's webinar.
And this concludes today's webinar. Thank you again, everyone, for attending our presentation, and we hope you found this information helpful in understanding critical employment law updates taking effect in 2026. And thank you again, Jeff, for being our guest attorney. We look forward to continuing to work with you on future presentations.
Thanks, Dan and Rosie. It was my pleasure. I always enjoy being here very much.
Thanks, Jeff. So if you enjoyed today's session, we invite all of you to view past webinars on demand within our digital resource library. You can access checklists, forms, and training materials that address topics discussed in today's session. To register your account and access the library, click the link in the chat window now. If you've already registered for the digital resource library, click the second link in the chat window now to log in. And then if you have any questions about the digital resource library or WorkWise Compliance, give us a ring. One of our customer service representatives will be happy to help, or you can access online in the link here. The phone number is currently in the chat window.
And to all of our attendees, thank you again for choosing WorkWise as your provider for labor law compliance solutions. We would like to ask you to please participate in the short survey that will become available at the end of webinars today. And have a good afternoon, everyone.